start today's lecture by one, reminding you that we have online chats every Tuesday night at 7. And I can do those more often if that's better for any of you. I want to make sure I can answer your questions. Email me, call me, or if you're in Oxford this summer and want to meet. Well, everyone, I hope things are going well for you. Before I start today's lecture on revocation of wills, I want to remind everyone that we do live chats every Tuesday night at 7 Central Time, and also that I'm available by email or phone. My phone number, my cell phone is on the syllabus. Please don't hesitate to ask if you have questions. We're getting close to that time of exams. So now's the time you want to start putting all this together. By the way, if you happen to be in Oxford this summer, I'm happy to make an appointment to meet with you, to answer any questions you have in person. I know this is an online class, but don't think that means you can't meet with me in person or Skype, or FaceTime. I'm available a lot of different ways. So please don't hesitate. The other thing I want to point out is that next week is the 4th of July, and the university is closed on Monday. So what I'm going to do is I am going to post my old exam. It's already actually on Twin, but I'll make sure you each have that copy of the old exam. Start going over it. It's a great way to review what we've covered. It's a great way to preview the types of things I can test on the exam in just a few weeks at this point. The summer is flying. So, make sure you take that practice test, and then we'll go over it. I'll spend a whole lecture going over that practice test and also explaining why the answers are the right answers. And so we'll use that. Then we'll have a chance later in the semester at the end, we'll do another review and we'll go over some sample questions. The best way to learn these materials, they're not difficult. So the best way to learn them is by examples and by application. And this is, it by its nature, a practical course. We can talk about will theory, we can talk about what should happen, but in real sense, this is very much practical law that helps your clients and helps their families at a time when they need that help the most. And at a time when your client will no longer be able to speak for themselves. So very practical application, which means it should be simple and it should be better understood by application than it is by theory. So, if you're kind of wondering, is this as simple as it seems? The answer is yeah, it kind of is. All right, don't tell anybody though. All right, here we go, revocation of wills. Well, last week we talked about execution of wills. I gave you a problem where there was faulty execution. It was based on a case that dealt with the McKellar estate. It was straight out of that case. And you'll get feedback this week. But the bottom line was the testator did not sign the bottom of the will. Clearly, what she wanted was evidenced in that document. You could read it, even though she wrote it herself. I left the errors in there, so you saw the SIC in there to let you know that it doesn't have to be great English. It doesn't have to be perfectly written, as long as we can understand what it is the testator wants. But the court can't even get there unless this document is validly executed. So that's kind of the entry point. That's the door the threshold we have to cross. And that may seem really technical, but it's important. And courts typically will not interpret a document until they find out it is a valid will. In that case, in the problem I gave you, it was not valid because she signed in the wrong place. And so that, again, seems like a real silly technicality, but that's our threshold. So just remember that. I never want any of you to fail at properly executing a will. And we'll move on from there. Now, once we made a will, it's not permanent. We can revoke it. We can change it. We talk about the fact that wills have an ambulatory nature, that they can, in fact, be changed, modified. You can have a codicil, which changes a will, which is really just an amendment to the will, or you can have a whole new will. And those documents, codicils and wills, need to be executed with the same formality as wills. So last time I mentioned that what you want to do is, in 2017, just have a whole new will. Deal with one document. It's going to make your life much easier than having a bunch of codicils that contain amendments over several different years. You want to have that one document that your client's family can go to and know what their instructions are, and know that they don't need to be looking for other documents that may modify that will. So your document is going to start off, your will is going to start off by saying, I, whoever your client is, hereby make this will. This is my last will. I hereby revoke all wills previously made by me. And that will serve the purpose of revoking previous wills and then adopting a new document. And then you're going to execute that will. So wills, the fact that they're ambulatory, means that as a person's life changes, as things in their lives change, they can have a new document, a new estate plan. Well, what are those things that give us a reason to make a new will? Well, birth of a child would be one. Divorce, an important one. Those of you that do family law always need to think about estate planning in addition to the divorce itself. What effect is this going to have on a person's will? What effect will it have on the beneficiary of their life insurance? That's important to think about. Right. Well, then you think about death of a beneficiary. Let's say I was going to give property to my cousin Sam, and Sam died. Now what happens? What will happen to the property I was giving to Sam in my will? Well, we're going to find out in the next segment when we talk about will construction as we get to next week. But one thing you want to plan for is that things do change. So if that happened, if major events happen in your clients' lives, you want to encourage them to come back to you and redo their estate plan or update their estate plan. Major swings in their financial fortunes certainly are reasons to consider further estate planning. Selling a house. A lot of times you'll say, I give you my house at such and such address because that's the house they're living at the time they wrote the will, but then they move. So, that's, something to think about. Now, one thing that we can put into a will is a contingency. So I give you my house at, then I would give my address for that house wherever I was living then, or whatever house I happen to own at the time of my death. That is a great way to deal with that particular change so that the person doesn't have to come back and make a will. So we need to think about, the future, that things are not static, and this person's life as it exists the time they're in your office will not necessarily be anything like the life they have at the time they die. So it's good that wills can be revoked. It's good that they're ambulatory. Doesn't mean they're out taking walks. It just means they're changeable. The other definition that we need to think about in terms of this ambulatory nature of wills is that wills expand really to cover whatever property your client owns at their death, if they don't, specifically name their property in their will. So, for example, if I say, I give you my bank account, well, my bank account is going to go up and down, mostly down this summer. My bank account is going to go up and down over time. So it's really whatever's in the account. It's not at the time I wrote the will or executed the will. It's at the time I die. My stocks, that kind of thing. My real property expands. So if I acquire real property 20 years after I execute my will, if I simply use the general term will, my real property, that property will be covered by my will. And one last thought though, if I do give specific property, and we're going to talk more about this next week, but let's say I give you specifically my 10 shares of Coca-Cola stock in my will that I write in 2017, but when I die in 2025, hope not, but when that happens in 2025, then if I don't own any Coca-Cola stock because I sold it in the interim, you're just out of luck unless I have thought about that and later changed my will when I sold the stock, or unless I say, I give you my 10 shares of Coca-Cola stock if I own Coca-Cola stock at the time of my death. But if not, then I'll give you the equivalent value of 10 shares of Coca-Cola stock at the time of my death. So that's a very simple way to do that. But we need to think about those potential changes. I don't know. I usually in class ask if anyone is a psychic. And I actually had somebody raise his hand in class one day and said he knew I was going to ask that question. I thought that was pretty funny, but I really don't believe in actual psychics, because if we were actual psychics, then we wouldn't need to worry about the ambulatory nature of wills. You would just be able to predict what the person was going to own at death and who they were going to be married to, or or sleeping with, or whatever. We're not psychics, so we need to have, as a part of our plan, some flexibility to take into account changes that might occur. Right? But we can also revoke wills and then make new ones to take into account those changes as well. All right, so the main methods of revoking a will are a subsequent will. This is the way you will do it. You will never replace an existing estate plan with nothing. All right, so you're going to revoke the previous will by a new will, a new replacement estate plan that is properly executed. A subsequent will is a writing that is executed with the formalities of wills. It can be a holograph in states that allow holographic wills. That's the best way. That is the best practices. So even though you can revoke a will by physical act, you as a lawyer will never encourage your client to do so. Now they can do it in addition to having a subsequent will. If it makes them happy, when you've executed their new will and revoked their old will, if it makes them happy to tear that will up, that's perfectly fine. Okay, the act of revocation will have occurred with that subsequent will. If they simply tear their will up, there is no replacement. Now we go back to intestacy. By the way, most states, we'll talk about this, but most states, Mississippi included, say, hey, you don't revive a previous will by tearing up the later will. Some states say, hey, if you tear up the later will, you go back to a previous will. Most states do not. So just know whether your state does that or not. But like I said, that's not the best way to effectuate an estate plan, simply by tearing up a will. Or, and then let's talk a little bit about what is a physical act. What's a physical act? Right. So, what does that mean? Tearing the statutes. If we looked at the statute, you should look at the statute of your state. Most of them will say tearing, burning, obliterating, canceling, something like that. An act that clearly shows that this act is intended to void that will. But we need intent too. Now the intent of revoking by a subsequent will is pretty obvious, because you're going to say, I hereby revoke my previous wills. That's intent. Intent on a physical act is always ambiguous. Why is that will torn up? Who tore it up? Was it the testator? Or maybe it was some disgruntled beneficiary. So you will not use physical acts as your way of effectuating a revocation of a will. You can, you legally can, but you won't. I'm telling you not to. I'll be mad if you do. All right, now revocation by inconsistency. It is possible that you have a later document that doesn't fully revoke the earlier document, and there are inconsistencies. So for example, I have a will where I give all of my property to my wife, and then let's say I made that will in 2015. Now in 2017, I decide I want to give my baseball card collection to my son. And so I say in 2017, I give my baseball card collection to my son. Don't say anything else in that document. All right, you can see that's inconsistent, because in the 2015 document, I gave everything to my wife. In the 2017 document, I'm giving the baseball card collection to my son. Well, my wife, therefore, by definition, won't be getting everything. So in a way, I've revoked that earlier will by inconsistency, but only to the extent of the inconsistency. So my wife still gets everything except the baseball card collection. And by the way, what we're going to call that second document even though it may say it's a will on its face, that's going to be a codicil. That's really what a codicil is. A codicil is a document that doesn't fully revoke the previous will, but just a part of it. Now, I could revoke a will by inconsistency completely. So let's go back to my 2015 will, and I give everything to my wife. And then in 2017, I'm not doing this, Donna, I promise you, in case you're listening, I write a will where I give everything to my lover, right? You know, so if I did that, then by inconsistency, now I've got one will that gives everything to my wife. I didn't specifically revoke that will, but in my later will, I give everything to somebody completely different. That's a revocation by inconsistency. And what that tells us is the later document controls, the later expression of intent controls, right? And that's true even within a will itself. Example, let me give you an example. So let's say I gave my baseball card collection to my son in Article 2 of my 2017 will, but in Article 4, a couple of paragraphs down, I give my baseball card collection to my daughter. Right? Well, now I'm inconsistent within the will itself. If you are the person who drafted that will, you screwed up. You don't want to do that, right? You want to make, I mean, that's clearly an inconsistency that's problematic. But the way a court's going to interpret that inconsistency is the later statement of intent controls. So if I gave the baseball card collection to my son early in the document, and then later in the document gave the baseball card collection to my daughter's going to get the baseball card collection. So you want to avoid those kinds of issues, obviously. I always think it's a good idea, even if your subsequent will, your later will, completely changes what you said in a previous will, to specifically say, I hereby revoke all documents, other wills, and codicils I've made before. All right, Harrison versus Byrd is an interesting case. Suppose TX properly executes her will in duplicate. Both copies are given to T. T later physically destroys one copy. Can the remaining copy be probated? All right, so let's talk about copies for a second. How smart it is to have duplicate executed copies of the will. Now, you can make a copy of a will that is executed on your, you can take it to a copy machine and make a copy. You want to put copy on it. It is not the will itself. It's simply a copy. If the will is lost and nobody can figure out what happened to the will, that copy can be presented in an attempt to probate that lost will, which does happen and can happen. Okay, so yeah, it's good to have a copy, but you do not want two properly executed copies of a will. You don't want the testator to sign both copies and have witnesses sign both copies. That is problematic, because if this happens where T physically destroys one copy, can the remaining copy be probated? Well, yes, it can, possibly. You would almost think that she would have had to have destroyed both copies in order to actually revoke the will. So you're just creating another problem for your client. Again, the simple thing to do, if you want to revoke that will, you write a new will that simply says, I hereby revoke that will, and all copies of that will. If you want to do that, you don't need to say that. You're revoking that previous will. So it's bad practice to have several originals, if you will. You just want one original. And you want to keep it in a safe place. You don't want your client having it if you can control that, because that's how they get destroyed. And then you don't know who destroyed it. They put it on their office desk, and their child, who is getting less than they want, tears it up. Or their child is 6 years old and spills things all over it, or colors all over it with crayons. Then the person dies not knowing that their child has done that. The will is found with all those marks on it, or obliterated, and somebody thinks maybe the testator wanted to destroy their will. So safekeeping is important. You want to make sure when you do a will for someone, you either keep it in your files, in your safe deposit box, or you have them put it in a safe place. They are perfectly free. Your client has the right to take that document with them. You just need to have a list of how they should safekeep it. Fire can destroy it as well. So we need to think about how that will is taken care of. We don't want our client to say and get mad and just tearing it up at some point, because then they're without an estate plan and they could die intestate. All right, so not a good idea to have 2 copies, but you can probate a lost will if you have a copy that shows that the will was executed. So, making a photocopy is fine. Just make sure you put copy on there so there's no confusion. All right, and really, we have 1 copy destroyed of where we have 2 actually executed copies of a will. Did that person mean to revoke, or did they mean just to simplify? My wife is a poet. She laughs sometimes that she has lots of writing, but she laughed and said, well, I got like 10 copies of the same poem. I finally got rid of the earlier copies and just kept the revisions. So, that may be what this person's doing when they tear up 1 copy. They may say, it's too confusing, I just need 1 copy. That's not intent to revoke. All right, so Thompson versus Royal. Yeah, I didn't ask you to read Thompson versus Royal, an old case, but basically, this is one of these situations where a client comes in and says to a lawyer who happened to be a former judge, it's an old case, I want you to revoke my will and write me a new will. And it was clear that whatever happened, the client didn't want the existing will to be their valid will. They did not want that at all. And the lawyer wrote void at the client's direction, or had the client write void on the back of the will. On the back of the will, not on the front, on the back. And then the lawyer made a memo about what the client wanted to have happen. And then the client unfortunately died fairly shortly thereafter. And the court held that even though it was clear what the client wanted to do, and that the client wanted the will that she had previously, she wanted it revoked, that the lawyer had failed to properly have the will revoked, because writing void on the back of the will was not enough of a physical act to meet the statutory requirement. All right, well, what does that mean? It means if you want to write void. Now, void is not a writing. Void may be in writing, but to be a writing, you have to have witnesses and a testator signature. That's what a writing means, or it has to be a valid holograph. So void, and a holograph requires a signature. Void on the back of the will, or a memo on the back of the will not revoke that will. Case after case after case says you have to deface the front of the will, the actual words of the will, in order to be counted as a physical act. So stray marks on the back don't count, and void on the back doesn't count. And so it's important that when we approach someone who is trying to revoke a will by physical act, that they do it properly and make sure that they burn, cancel, obliterate, deface the front of the will. All right, so is there malpractice? Yeah, I mean, this particular judge was really, at that point, professionally embarrassed for the rest of his career because he screwed up. Uniform Probate Code, you can look at 2-507. It gives a lot more flexibility. In a case like Thompson versus Royal, it would have said, hey, we'll look at it again, intent, which was clearly stated, and the lawyer was willing to testify. It was clearly stated. But I don't want to rely on that. What I want to do is be so clear that there's no question, and that's why we do these things in writing. What the lawyer should have done was if in a state that allows holographs, have the client write a quick holographic will that says, I hereby revoke my previous will. Here's what I want to happen to my estate. And that way, if the client died in the interim, the client's estate plan would still be effectuated. If the lawyer is not in a state where there's a holographic will, what that tells you is the clock is ticking. So you need to take the time frame of making a will seriously, because otherwise what might happen is you may wait too long and it may be too late to make that estate plan. Now, that's only going to be a problem for you in cases where it's pretty obvious that that person's time is limited, but you need to make sure you are diligent about completing someone's estate plan, no matter what their age is. And there are cases that have come out recently that say privity is not at issue. So that what does that mean? Y'all probably remember privity from contracts law. You can sue somebody for, if you are a beneficiary that would have taken something from an estate, but for the fact that the lawyer doing the estate screwed up, you can, in many jurisdictions, sue as a third-party intended beneficiary. So, that's something to think about. We want to know the time is ticking, and to make sure that we're quick in getting these wills done and that we get the estate plan done before our clients do the inevitable. All right, another one, I'm going through a lot of cases, but let's see. Mr. Barry, give my entire estate as follows, the Barry case, as follows. My farm to niece, my car to nephew, the residue of my estate to X. We haven't talked about residue, but residue is just a catch-all phrase. So, notice here the farm is given to the niece, the car is given to the nephew, everything else is given to X. As an estate planner, excuse me, as an estate planner, that's a great tool for you, because then you don't have to list all the rest of that stuff. I mean, whatever else comes into my estate, whatever else the person already owns, that's going to go to X. All right, and then you got Mr. Barry signs and 2 witnesses. Now, Mr. Barry gave his entire estate as follows, right? So here's the farm to niece. He writes void only on the gift to niece. That could be a physical act. Again, even though it's a word, it's not a writing because it's not a holograph and it's not a valid executed document. So he writes void across my Iowa farm to niece. Cars to nephew is not marked out. Residue to my estate, of my estate to X, knocked out, not knocked out. Well, what's important about this? I didn't ask you to read the Barry case either, but it's a great fact pattern, because the question you should be asking yourself right now is, can I revoke just a part of the will by act? You can certainly revoke part of the will by writing, a subsequent writing. You can change it. Can you revoke part of the will by physical act? And the answer, well, you're in law school. What do you think the answer is? And the answer is, it depends, right? It depends on what jurisdiction you're in. Many states allow a will to be revoked in whole or in part by physical act. Some states do not. You need to look at the statute in your jurisdiction to decide, what does my jurisdiction say about revocation by physical act? And the way they'll do that is they'll say a will may be revoked by writing or by physical act, burning, canceling, obliterating the will, coupled with intent, or they'll say a will may be revoked in whole or in part. Well, if we're in a jurisdiction that allows partial revocation by physical act, what's going to happen? What's going to happen is the gift to assuming this was the testator who wrote void on this gift, and assuming the testator intended to revoke this gift. So we need to make sure we know that, or can prove that. And it seems pretty obvious on the face of the will that somebody wanted to void out this gift. That Iowa farm will no longer go to the niece, right? If we can prove that act coupled with intent. We have the act. If we can prove the intent, then the farm will no longer go to the niece. Well, then what happens to it? Well, the car would still go to the nephew. The farm would be a failed gift to the niece because it's void, would go into the residue. So X would get the farm, because any gift that's not effectively disposed of by the will goes into the residue. Okay, hope that makes sense. So check your statute. Some states do not allow partial revocation by physical act, and that's important. Again, you're not going to be doing it. Now, why it's important in states that allow partial revocation by physical act, and your client has control of their will, and they start making pencil marks through parts of their will, that could be an effective partial revocation by physical act. On the other hand, if we're in a state where partial revocation by physical act is not permitted, like let's say Mr. Barry lives in a state where partial revocation by physical act is not permitted, the choice is either the whole will is void or only the part, or the whole will is valid, excuse me. The whole will is either void or valid. And so we have to look at intent based on this voiding the one gift to niece and decide if we're in a state that does not allow partial revocation by physical act, what should happen? And the answer should be that, well, then the niece still gets the farm, because either the whole will is void, which it doesn't appear the client wanted to have happen, or none of it's void by physical act. Again, the effective way to do this, as a lawyer, you draft a new document that gives the car to the nephew, the residue of the estate to X, Mr. Barry signs, witnesses sign. That's effective to carry out his wishes. All right, partial revocation, that's really what we just talked about. Are they valid, and what is the effect on the remainder of the will? And I think the Barry case was a good example of that. So just, look at that fact pattern. Again, if you're in a state that does not allow partial revocations, and a client has put pencil marks through one or two sentences, the court's going to have to decide, did they intend to revoke the whole thing, or should we leave the whole thing valid? In states that allow partial revocation, those partial revocations may be given effect. All right, dependent relative revocation is probably one of the most difficult things we're going to cover, but it's not hard, and that may sound crazy, but I'm going to take you through this. I'm going to take you through it, and I'm going to tell you a story about dependent relative revocation, or a story that relates to dependent relative revocation. All right, my children, when they were younger, I would give them a choice sometimes, and I would say, do you want to go to the pool, or do you want to go to the park? And sometimes their answer would be Chuck E. Cheese. Now, I had given them choices of the pool or the park, and Chuck E. Cheese was not one of the possibilities, but they would nonetheless prefer Chuck E. Cheese. Now, Chuck E. Cheese, any of you ever been to Chuck E. Cheese know there's a reason why they serve beer at Chuck E. Cheese. It's to help the parents get through a really, relatively horrible experience, although I have to confess, I kind of like Chuck E. Cheese, but for most parents, it's really kind of painful. Now, my children are old enough now, they never ask to go there anymore. There's usually some other option that I have not thought of that they're going to present to me. All right, so Chuck E. Cheese is not an option to them. They have to really think about, what is their best second choice? The park or the pool? All right, well, what's that got to do with wills? What's that got to do with wills? Well, dependent relative revocation is the Chuck E. Cheese doctrine. All right, I'll tell you why. All right, let's say I make a will in 2017. I decided to make my will in 2017. And I leave everything in my will to my wife and children. And then in 2019, I leave everything to some stranger in 2019. All right, and so the 2019 will revokes the 2017 will, and my estate plan at this point is I'm giving all my property to the stranger. But then the stranger and I part ways, and I decide I want to go back and give everything to my wife and kids. So I use a physical act to tear up my 2019 will. And as I tear it up, I'm declaring I am tearing up my 2019 will because I want my 2017 will to be valid again. The 2017 will is Chuck E. Cheese. Once it was revoked, it can't come back in most jurisdictions. Again, there are a couple of exceptions, but most states say once a will is dead, it's dead. So even though I think I'm tearing up my 2019 will and therefore reinstating my 2017 will, that's not what's going to happen. I can't, it doesn't, because the 2017 will is Chuck E. Cheese. That leaves me with the choice of intestacy or the 2019 will. Now, in that case, because my original 2017 will had given property to my wife and kids, I would probably prefer intestacy to the 2019 will that gave everything to a stranger. So the court's going to say I died intestate. But let's do it a different way. Let's say that my 2019 will didn't change much from my 2017 will. Let's say that my 2017 will, I gave all of my property to my church and $1,000 to my wife. And then I made a 2019 will where I just gave everything to my church. And then I decided later to tear up that 2019 will. I say, you know what, I no longer want to give everything to my church. I want my wife to still get that $1,000. So I'm going to tear up that 2019 will with the intent to reinstating my 2017 will. Well, if you can't revive that old will, that 2017 will, then a court is left with the problem of deciding, did I really intend to tear up that 2019 will and die intestate? Because that's my choice. Once you tear that will up, once you have that physical act, you haven't replaced it with another estate plan. And even though you think you're going back to that previous will, you're not. So if I tear up that 2019 will, a court could look at it and say, you know, this person tore up the 2019 will thinking they could go back to the 2017 will, thinking they could go to Chuck E. Cheese. But they can't. So since if they had known the 2017 will couldn't be valid again, would they have ever torn up that 2019 will? So the choice really that comes down to the court. Is the last will they did, the 2019 will, still valid, even though it's torn up, or did they die intestate? And it's a much harder, the last example I gave you is a much harder question, because if my wills both gave most of my property to my church, and the only difference was the $1,000 my wife would have gotten in 2017, a court may say, hey, this person would have rather died with their 2019 will than die intestate. So how do we get there? What does this doctrine really do? Well, remember we said that revocation by physical act requires intent to revoke plus the physical act. So a court could interpret my intent in revoking my will as faulty. If I revoke the will based on an assumption that doing so would revive a previous will, then I really didn't have the full intent necessary to revoke that last will. So the choice in dependent relative revocation is never the client's first choice. It's never really what they wanted. When you have dependent relative revocation, typically they want to tear up their last document and restore a previous document. And the court then is faced with, hey, if they had known they couldn't do that, would they have ever torn up that last document? Now, dependent relative revocation can also apply to partial revocations too, and we'll see some examples of that. But all I really want you to know about dependent relative revocation, other than the great Chuck E. Cheese analogy, is that it is a doctrine of second intents, really, second choices. Because the first choice is not available to your client, the court needs to interpret what would their second choice be. And in doing so, what they're really saying is, we can overturn their intent to revoke. We can say they did not have intent to revoke that last document because their intent was based on a faulty presumption. You may want to rewind this and listen to it a couple of times, but once you understand it, you will understand it. It's really not that hard. All right, so it's to remember, dependent relative revocation is to effectuate likely intent. And what we're going to look at is the evidence from the similarity of the language. So, for example, when both of my latest wills give almost everything to my church, and the only difference is my previous will gave $1,000 to my wife, they're not that different. So I would probably rather die with that later will than die by intestacy, because intestacy would be really different from my last will. So that's what they're going to look at. It's also true with partial revocation, and you'll see, we'll do some examples of partial revocation and dependent relative revocation. All right. So The Carter case is one of those cases. It's kind of the classic dependent relative revocation case. So in 1963, will executed in this case was properly executed, but found with a mark on some of the dispositions and through the name of an executor. There were marks of cancellation evidencing a revocation. In 1978, there was a handwritten will that was unwitnessed, or handwritten document that was unwritten, with distribution somewhat different than the 63 will, but not completely different. And the question was the 63 will revoked? And the court said that the 63 will was found with ineffective 78 will, creates a presumption that the revocation of the 63 will was dependent on the validity of the 78 will. So let me say that a little bit better. I read the screen is all I did just then, but I didn't explain it. Now I'll explain it. All right, so you got a 1963 will, the earlier will. It doesn't really matter what the date is. And the client clearly marked through some stuff on there and then tried to replace that information in the 63 will with some ineffective statements in a 1978 will. But they weren't that different. They were somewhat different, but not that different. Close enough to the 63 will that they weren't that different. It was clear the client wanted to make some changes, but did not do so effectively. So now the court just has to decide, was that revocation, that mark out through the 63 will, those partial cancellations in the 63 will, were they revocations? And the court says, well, it looks like the only intent the testator had was to change their 63 will by what they wrote in 1978. And if those things in 1978 were not valid, they would have never, if they had known that, they would have never revoked the 63 will. So the 63 will was actually held to be completely still valid, and the marks found through the dispositions were just ignored by the court. They actually looked at those marks, ignored them, said they're not revocations because the intent to revoke was not there. So anytime you see dependent relative revocation, it's really about the question of not the physical act which occurs, but was the intent to revoke effective to revoke that document. In the Albany case, the Carter versus First United Methodist Church, the 63 document and the changes proposed in the 78 document were close enough that the court would say, hey, the only way we would revoke or say there was a revocation of parts of the 63 will were if the 78 document was effective. Again, we as lawyers can do this so easily by making sure this later document is validly executed. That solves this whole problem. You're really not dealing with dependent relative revocation in situations where you have a later validly executed document. And by the way, if I want to revive, if I'm in a situation where what I want to do is revive my 1970 will, here it is 2017, if I have a will in 1970 and I want to revive it, what I'll say is, I hereby re-execute my 1970 will with all of its terms, sign me, witnessed. All right, so you can easily revive an old document simply by re-executing that document. That would become a 2017 will in that case. So it's easy to do. It's the right way to do it for your clients. Don't mess with any of this physical revocation crap. Okay, it is crap. And so here's dependent relative revocation in terms of a partial revocation. Right? I give 5,000 to A, I give 10,000 to B. All right, and I make scratch outs, and I try to increase A's gift to 7,500, and I try to decrease B's gift to 8,000. This is, to me, a really great example, not because I came up with it, but I think it's a much easier to understand example of dependent relative revocation. Because if you look at this, I can't increase A's gift, and I cannot decrease B's gift. Those are not valid writings. By the way, I will make one caveat. If this was a holograph, if this was solely in my handwriting, signed by me, then I can make these changes. All right, so yeah, I mean, we allow scratch outs on holographs because how do we know when the testator made those scratch outs. So courts will give a little more latitude to these kind of changes on a completely holographic instrument. But in a validly executed, signed and witnessed document that's typed, and we're assuming this is a typed document here, you cannot make these changes. These are ineffective. All right, so now what's the court supposed to do? Let's say you're in a jurisdiction where partial revocation by physical act is allowed. And now the court's looking at, I give scratch out to A, I give scratch out to B, and of course looking at that, and they can see that $7,500 is written over the gift to A, and $8,000 is written over the gift to B. What should happen in that case? All right, well, if you think about this logically, the court has two choices. They could say both of these gifts have been revoked because they are scratched out. A's gift cannot be enhanced, B's gift cannot be lowered. The choice is all or nothing. Either both gifts have been revoked, or maybe one gift has been revoked and the other is not. Or we could allow both gifts to still be the amounts that were originally in the will. All right, so if you look at this, I mean, let's think about the intent here. Let's think about this in relation to dependent relative revocation. The $7,500 written above A's gift and the $8,000 written above B's gift are Chuck E. Cheese. They're not happening, right? That's not going to happen. So the doctrine of which is the better second choice comes in, dependent relative revocation. And we could ask, and we could say, if the testator knew that they could not, in fact, increase their gift to A, would they rather A get $5,000 or nothing? Because that's the choice the court is faced with now. And I hope that all of you are saying, as you listen to this, 5,000. Well, what does that mean? It means that, yes, there was a scratch out. Yes, there seems to have been an intent to revoke that $5,000 gift, but the testator only did that with the provision that he could or she could raise A's gift to $7,500, and that can't happen. All right, so because the testator could not increase A's gift, certainly the testator, if you could ask them, would say, well, certainly I'd rather A get $5,000 as opposed to nothing. I thought I scratched it out with the intent to increase the gift. That's dependent relative revocation. $7,500 can't happen. So our choice is 5,000 or nothing. And a court, even though they see that scratch out, and even though testator may have intended to scratch it out, it was clear they only scratched it out if, in fact, they could raise the gift to $7,500. So A will get $5,000 if this is my court, if I'm the judge. All right, what about B? Well, the intent here is a little bit trickier because we're clearly going to try to lower B's gift, or we would rather lower B's gift to 8,000. That's what testator would tell you. I thought I could lower B's gift from 10,000 to 8,000, but you can't, testator. So that being the case, would you rather B get nothing because you scratched out B's $10,000 gift, or would you rather B get $10,000? You know, that's a little bit harder case. And what courts will look at when there's an attempted decrease in a gift is how much of a decrease is there. Now, I think it'd be comfortable for me to say as a judge, I'd still give B's $10,000 because there's not enough difference between 10 and 8 that it's clear that B should get nothing instead of this gift. Now, if the gift was lowered to $100 from 10,000, it would be okay to say it was, even though the gift of 100 is not effective, that the testator's intent to revoke that $10,000 gift was pretty strong, and therefore B would get nothing. All right, so when we look at dependent relative revocation in a partial revocation situation, we're looking at a testator who tries to change the gift somehow, and that change is ineffective. And so then we got to decide, all right, would they rather have scratched out the gift completely, or would they rather have the person take the original gift that they scratched out? The state of Auburn, this is for those of you that are historians, this is the case, in my opinion, that started dependent relative revocation. And so I'll quickly go through the facts, but it's really just, it reiterates what we've talked about to this point. It's a Wisconsin case, and there is no revival under Wisconsin law. right? Kentucky's in Illinois, but anyway, there's no revival of wills under Wisconsin law. The testator in this case made a will in Milwaukee in 1955, made a 1959 will, the Kankakee will that was, the later will, which revoked the Milwaukee will. There is no revival in Wisconsin. So when the testator tears up the will, the 59 will, she even said, I'm revoking this 1959 will because I want to go back to the 1955 will. And the truth is, there wasn't a lot of difference between the 59 will and the 55 will. But she clearly tears up the 1959 will with the intent to revoke it. But that intent was dependent upon revival of the 55 will. The court in Auburn said, you know what? Let me go back for a second. The court in Auburn said, well, we have two choices here. The 55 will cannot be revived. We cannot give effect to that. It's Chuck E. Cheese. They didn't say Chuck E. Cheese back then. Chuck E. Cheese hasn't been around that long. Those people in 1955 did not know what they were missing. Those poor people. But the 1959 will was a possibility, because the court could say, hey, intestacy was so different than either of these documents, than either the 1959 will or the 1955 will. And it was clear the testator revocation of the 1959 will was dependent on the 1955 will being valid, which is not true. That what we'll do is, even though this 1959 will is destroyed, it's in pieces, we'll probate the 1959 will. That's dependent relative revocation. All right, so we're going to probate this will that's been torn up because it better effectuates the intent of the testator than intestacy would. I hope that makes sense. All right, revival is a doctrine that is really dependent upon the jurisdiction. There are a lot of jurisdictions like Wisconsin, we just talked about, that don't allow revival. Check the statute in your state. Does it allow revival of revoked wills by physical act? You can always revive a revoked will by a subsequent writing reviving that will. That's easy. That's what lawyers should do. But if I tear up my last will, does that bring back the previous will? Most states would say no. Some states say yes, and that's what revival is about. All right, there is also an important concept called revocation by operation of law. And this is important because there's some changes in a person's life that will give rise to revocation. Divorce. Most states will say a divorce revokes provisions of a will that relate to the former spouse, unless there's clear evidence that that's not what the testator wants to do. So if I write a will and say, hey, I want my wife Donna to take everything from my estate, even if we get divorced, then this provision will not prevent her from doing so. But divorce will typically, in almost every jurisdiction, revoke that portion of the will that relates to the spouse. The spouse will not take, they'll be treated as though they predeceased the testator, and the property will pass accordingly. All right, some states say a divorce or a marriage actually revokes all previous wills. So most states will just affect the spouse, but marriage could revoke a previous will, because the assumption is if you got married after you made your will, that's a big enough of a life change that you hadn't thought about this new person that is now your spouse, and therefore the will, any previous wills are void. So revocation by operation of law, things that happen in a person's life that have an effect on their will. Effect on alternate, because if the spouse dies before me, then X. So if I get a divorce and I said, I still have a will that leaves everything to my spouse who's no longer my spouse, then it makes sense that the law would say, hey, my spouse is, we assume that you don't want to leave all your property to your ex-spouse. then it will go to the alternative taker. So if spouse dies before me, then to X. If I get divorced, then my spouse will be treated as having predeceased me, so my property will go to X. If you do family law and you do estate planning at all, this revocation only, in most states, only affects provisions in a will. Sometimes it'll affect provisions in a trust as well, but it typically will not affect provisions in a life insurance policy, provisions in a retirement plan. Those are things you need to sit down with your client and have them write the company, the insurance company, the person, the entity that manages their retirement plan, and change their beneficiary. I think I've told y'all, and it's worth repeating. I know if you had family law with me, I told the story. I had a colleague who taught with me at another school. He was an icon, a really great guy and a great teacher who had been married once before and got remarried, had a child later in life with his next wife, his second wife. He actually died while he was grading exams one semester. And he had never changed the beneficiary designation on his retirement plan. And so his first wife was still listed as the beneficiary. And what that meant was his second wife and his child did not get his retirement plan. So even though that was Florida, even though Florida had provisions that revoked the portions of his will that related to his first wife, it did not revoke any third-party beneficiary designations related to his first wife. You as a family lawyer, you as a divorce lawyer, that's one of your jobs you have to do, because I think his lawyer failed him very badly in that situation. And he was a lawyer, so he didn't think to do it either. All right, and that's when I put effect on non-probate assets, that's what I just talked about. Most statutes affect probate assets and say the divorced spouse doesn't get them, but it doesn't have any effect on these outside contracts that don't go through probate. Life insurance is one of them, retirement plans the other. Look how pretty in pink right there. All right, what makes up a will? What makes up a will? Can we have documents that are not actually stapled into the will as part of the will? And that's what we talk about, integration of wills. Well, first of all, one thing that you're going to do is you are going to number the pages of your document for your client, and they are going to initial each page. And the other thing I think is a good thing to do is never have a page end, never have a page end on a complete sentence. All right, because we want to show that the bottom of one page flows directly into the top of the next page, so there's no question that anybody inserted any document into this will that wasn't there at the time your client signed it. You're going to have it stapled. I mean, all this stuff is common sense, right? And if it's such common sense that it will amaze you how many cases there are where pages of the will are just spread on the floor somewhere, and they're not numbered, and somebody has to figure out how they fit together and which pages were actually there at the time of the signing. So when your client signs that will at the end and has those witnesses sign at the end, we want to be clear what comprises that will. Right? And that's why it's important to think about, making sure pages are numbered and initialed by your client. Every page initialed by your client. We want to make it easy. But what about things that aren't actually in the will? Can I refer to a document? Can I refer to something else in my will so I don't have to retype it? And the answer is yes. There's something called incorporation by reference. So if I have a trust that I've written and I want to refer to that trust in my will, then I can say my property will pass according to the terms of the Gershon family trust, adopted May 2017, and then I sign that document. All the terms of that trust then are incorporated in my will by reference. We can only incorporate in our will documents that actually exist at the time of the execution. You can republish a will by codicil. We talked about the fact that when a will is amended, we have codicils. The will then be amended as of the date of the codicil. So if I have a will that I made in 2000 and I have a codicil that changes some of that will, then that I make in 2017, the whole thing becomes a 2017, not 1927, a 2017 will. All right, and there's incorporation by reference. I talked about that. Now, incorporation by reference really is a situation of a republication of codicil updates the will, and so that the will itself, the terms of the will become incorporated in that codicil. Other documents can be incorporated in a codicil as long as those documents previously existed. And one last thing I want to talk about is acts of independent significance are part of a will as well. If I say to you, I give you my car, and right now I am driving a Camry. I'll probably die driving a Camry. I mean, they're just, they last forever, assuming they don't have Takata airbags in them. Then they're great, safe cars. This is not an ad for Camry, but it could be. So probably, who knows? But let's say instead, I happen to be driving a Camry in 2017 when I make my will. But in 2025, I happen to trade my Camry in on a Porsche, and then I die. And my will says, I give you my car. What do you get? Do you get the Camry that I no longer have? Or does my estate have to go buy you a Camry, since that's what I owned when I made my will? Or do you get the Porsche? And as you might guess, you get the Porsche, because you get whatever car it happens to be that I'm driving at that time. Because the assumption is whatever car I'm driving has not any impact on my estate plan. In other words, I'm not really thinking, I'll go out and buy a Porsche now because I've given my car to you. Instead, I'm probably going to drive a Porsche because that's what I want to drive at that point. So acts of independent significance are things that change just naturally in my life that, that I am doing irrespective of my estate plan. So if I tell you I'm giving you the contents of my desk drawer, well, those contents of my desk drawer change every day. I don't have to make a new will every time my contents of my desk drawer change. You will get the contents of my desk drawer that exist at the time I die. So, you'll hear that term, acts of independent significance. It's really not difficult. It's not a hard concept. Just think about, the things that change over someone's lifetime to their car, their house, their contents of their desk drawer, my bank account. My bank account goes up and down. Those are all acts of independent significance. All right. We will stop here today because that's enough for one lecture. And when we come back, we'll talk about contracts affecting wills. You don't want to do them. Contracts affecting wills are binding agreements to make a will or not to revoke a will or not to make a will. And we'll talk about why these are bad ideas in our next segment. So what I mainly want you to focus on then for this week is the materials on revocation. Also look at the materials in the week 5 materials. There's some a PowerPoint for clickers. You don't have the clickers, but what I want you to do is go through and see if you can answer those questions on revocation and dependent relative revocation. I think they'll help you review, and then I'll go over those with you in our next set of lectures. Have a good week. Have a good 4th of July, and we'll talk to you soon.